कॉन्सेप्ट्स पढ़ाएंगे, सबको सिखाएंगे। दिस इज़ अ वेरी बेनिफिशियल सीरीज बाय आई एग्जाम बी। आज के इस वीडियो में हम लोग नया टॉपिक लेने वाले हैं, दैट इज़ फ्रॉम लॉ ऑफ टॉर्ट्स एंड इट इज़ अबाउट स्ट्रिक्ट एंड एब्सोल्यूट लायबिलिटी, वेरी कॉमनली डिस्कस्ड subject under torts. The difference between these two kind of liabilities we will clearly understand with the most landmark case laws. वेलकम टू आई एग्जाम बी। अगर आपके कोई भी क्वेरीज हैं आप हमें डायरेक्टली hello@iexambee पर लिख सकते हैं .com एंड यू कैन ऑल्सो विजिट द वेबसाइट www.iexambee.com। आप इस वीडियो के कमेंट सेक्शन में भी लिख सकते हैं। सपोज अगर आपको कोई सब्जेक्ट में डाउट है, कोई लॉ के टॉपिक में आपको conceptual clarity नहीं है, it's not enough, you can write to us in the comment section. We will definitely try to bring a video on it. So don't forget to subscribe. No fault liability. This is what is the genus term for these two kind of liabilities under law of torts. No fault liability, then as the name suggests, means what? That the person on whom liability is being imposed is not at any kind of fault. No fault liability. So this no fault liability is the genus term. It is divided into two kinds of liabilities. One is strict liability and one is absolute liability. Strict liability is actually developed by the English courts. It is an common law development, whereas absolute liability was given to us by Indian judiciary. That is, around 1980s we have got this concept. It is an extension of strict liability only, but there is a difference between both. We will see that in detail. But पहले आपको इसका basic clear होना चाहिए that from where these two kinds of liabilities are coming up. That is no fault liability. In both the kinds of liabilities, there is no kind of direct intention at the part of the wrongdoer. The liability we are imposing on him is not due to any kind of direct intention or concrete intention. Might be due to some kind of negligence at his past, that he did not take care in the manner he should have taken care. He could not foresee certain circumstances. So his fault is not there actually, but the liability is so grave that he should have take care of that particular thing. ये इस liability का logic है. Strict liability की पहले हम बात करेंगे. It has developed in the case of Raylands versus Fletcher in the year 1868. So law of torts, as we all know, has come to India from the common law, and Raylands versus Fletcher is a very famous case. It is very important. Strict liability नाम सुनने के बाद आपको Raylands versus Fletcher click होना ही चाहिए. In this particular case, the facts was that Raylands and Fletcher, they were having their lands adjoining to each other, and some mine shafts were there on Raylands' land. Fletcher was trying to construct some reservoir on his land. Due to that construction, some water went into the mine shafts of Raylands' land. So Raylands wanted to seek certain compensation from him and impose liability on Fletcher. So it is about keeping dangerous things on your particular land and escape of that particular thing. So if you are keeping any kind of thing which is dangerous, liability was imposed on Fletcher because of the escape of dangerous thing that he had kept on his land. This is what is the rule of law that was said, which is important, that if you are keeping any dangerous thing in your property, you are inherently liable for it, and even if you are not having any fault directly, but keeping that thing on your land, if it can escape and go to some neighbor's land or to somebody else's land, then you will be liable to it. ये strict liability का concept है. But it is subjected to certain kinds of exceptions. Let us see what exceptions are there to strict liability. These are defenses that can be taken against strict liability. Plaintiff's own fault. Then it can be act of God. It can be voluntary non-fit injuria, mutual benefit, act of stranger, and acts by a statute under a statutory authority. Plaintiff's own fault means what? That the plaintiff himself is at a fault. If the plaintiff himself is at a fault, so he cannot seek compensation from the defendant because his fault has given rise to that particular kind of liability. Act of God is something which is unforeseeable, it is unexpected. Then voluntary non-fit injuria is that when voluntarily you are consenting to a particular act, then strict liability cannot be applied there. Mutual benefit, if the plaintiff also is having some kind of mutual benefit in that particular act, wrongful act, then there won't be any kind of defense available to him. Act of stranger, अगर कोई act of stranger है जो intervene होता है उसमें, उसके लिए strict liability डिफेंडेंट पर आप इम्पोज नहीं कर सकते अगर कोई एक्ट ऑफ स्ट्रेंजर उसमें इंटरवीनिंग कॉज बन जाता है. स्टेट्यूटरी अथॉरिटी मीन्स अगर कोई स्टेट्यूटरी एक्ट के अंडर या कोई स्टेट्यूटरी अथॉरिटी ने कोई एक्ट किया है दैट इज लॉफुल बाय दैट पर्टिकुलर स्टैट्यूट, देन अगेंस्ट दैट ऑल्सो यू कैन नॉट इम्पोज अ स्ट्रिक्ट लाइबिलिटी. द नेक्स्ट कंसेप्ट, एब्सोल्यूट लाइबिलिटी. Absolute liability, as I told you, is also a form of no fault liability only, but the only difference is that it is not subjected to defenses. यानी कि जो defenses का relief था वो भी नहीं होगा. Strict liability minus the exceptions is what amounts to absolute liability. As the term suggests, what absolute means, that absolutely you will be liable irrespective of the defenses, irrespective of everything. Just what will be focused is the consequences. इसका बेस्ट केस कौन सा है? भोपाल गैस ट्रेजेडी केस. एवरीबडी नोज यूनियन कार्बाइड कंपनी, ड्यू टू दैट कंपनी मिथाइल आइसोसाइनाइड हैड लीक्ड. So because of the leak of gas, everybody was affected across the city in Bhopal. So in this particular case, actually absolute liability concept was developed, and the statement was also made by justice in this particular case that some principles get obsolete with time. It's not necessary that law of tort principles which are applicable in 1868 will also apply in 1980s right now. That is Reliance versus Fletcher का रूल. So उसमें से exceptions को निकाल दिया गया and absolute liability का principle apply किया गया, and the people are still getting compensation out of that particular liability that was imposed on the Union Carbide Corporation. So I hope you are clear now on the difference between both the kinds of liabilities, and both are very important for your exam also. If you are giving any exam जिसमें tort syllabus में है तो ये काफ़ी important topic है. Don't forget to visit the quiz that is there along with this video, as it will give you a quick idea that whether you are getting the concepts or not. Prepare 50% faster with iExamB. Don't forget to subscribe. Thank you.